1.2 billion euros. No, it's not a typo, it's a fine for one company, one category of violation. Also not a great day to be in their legal department. And it wasn't even the only massive fine that year. Today we're looking at the 5 biggest GDPR fines ever issued, what went wrong in each case, and what any organisation handling personal data should take from them. Quick bit of context before we get into the numbers. European data protection law didn't start with Silicon Valley or smartphones. It started in 1945. When Allied forces moved through liberated Europe, they found something deeply unsettling. Meticulous government records, names, religions, addresses, information that had been used to locate and destroy entire communities. The lesson was simple and brutal. Information about people is power over people, and that power will be abused if there are no rules around it. That thinking shaped decades of legislation, eventually becoming the GDPR in 2018. A single regulation, applying across every EU member state, giving people real rights over their data and giving regulators the teeth to enforce them. So, how sharp are those teeth? As it turns out, extremely. Let's start with the 5th largest fine ever, TikTok. The fine cost is 345 million euros, and it was handed down in 2023. The violation involved children. Specifically, TikTok was found to be collecting and processing personal data from kids under 13 without proper legal basis, and their accounts were set to public by default, which is, to put it very mildly, not ideal. Under GDPR, children get extra protection for a reason. They're less equipped to understand what it means to share personal information online. TikTok knew the rules. They still chose engagement over protection. The fine followed. Picture this. You sign up for a platform. Somewhere in the terms and conditions, it says your data will be used for personalized ads. The platform calls this your contract with them. They call it a legal basis. Regulators had a different opinion, and that brings us to the 4th largest fine. In January 2023, Meta was fined 390 million euros for using contractual necessity as the legal basis for its advertising data processing in a way that users couldn't actually understand or meaningfully challenge. Facebook accounted for 210 million euros of that. Instagram, the other 180 million euros. The point isn't that Meta processed data, it's that they couldn't clearly explain why they were allowed to. If you can't articulate your legal basis in plain language, you probably don't have one. Meta again, so same company but different violation, and somehow an even bigger number. In September 2022, Instagram was fined 405 million euros, this time for publicly disclosing the email addresses and phone numbers of children who had accessed the platform's business account feature. And again, setting minors' accounts to public by default, same pattern as TikTok. And that's not surprising, as these aren't isolated mistakes. They're product decisions that treated privacy as an obstacle rather than a requirement. Moving on to our number 2 spot, the questionable honour belongs to Amazon. In July 2021, Amazon was fined 746 million euros by Luxembourg's Data Protection Authority. At the time, the largest GDPR fine ever issued. The issue was consent, or to be more precise, the complete lack of it. Amazon had been tracking user data without getting proper consent and without giving users a real way to opt out. Every time you browsed, every recommendation, every ad following you across the internet, you look at one thing once and suddenly it's everywhere. All of it built on a data collection model that didn't meet GDPR's standard. Consent under GDPR has to be freely given, specific and informed. And it has to be just as easy to withdraw as it was to give. And then there's this one. It was handed down on May 22nd, 2023. Ireland's Data Protection Commission issues the largest fine in history, 1.2 billion euros against Meta. Why? For transferring European Facebook users' personal data to servers in the United States. Here's why that matters so much. Back in 2020, the European Union's highest court struck down the Privacy Shield framework that thousands of companies had been relying on for transatlantic data transfers. The reasoning was straightforward. US surveillance law allows US intelligence agencies to access data held on American servers in ways that would be illegal under European law. The framework didn't provide adequate protection, so it was invalidated. Meta kept transferring data anyway, which, as a strategy, really did not age well. They argued their standard contractual clauses were sufficient. Regulators disagreed. After years of investigation, the fine arrived. While Meta is appealing, the principle is settled. Transferring European personal data to a country without adequate protections is a serious breach, and if you're one of the biggest data processors in the world, the fine will be proportionate to that. 5 fines. Over €3 billion combined. So what's actually going on here? None of these companies set out to break the law. They made deliberate product and business decisions that put growth ahead of compliance. But the law doesn't ask about intent. It asks whether the rules were followed. In every case here, they weren't. Data protection is a fundamental right. It's backed by law and enforced with real money against the biggest companies in the world. If you're responsible for data at any level in your organization, take that seriously. Because the regulators clearly do. Want more on data privacy, on compliance and corporate training? Check out our blog post on the European Union Artificial Intelligence Act. Links in the description. See you next time.